Hi, Bridget Mackay here with the law offices of Bridget Mackay. I do estate planning and elder law. I'm here in Petaluma, California. And today I want to talk about Medi-Cal Recovery. So if you are on Medi-Cal, if you've gotten any long-term care through the Medi-Cal program or long-term care program, they have a right when you die or you and your spouse pass away to recover from your estate for the monies that they spent on your care. And that could be pretty steep. I've seen recovery claims anywhere from as low as $1,200 to as high as $400,000 or $500,000. So this is a tale of caution and another one, in that I had a client call whose mother received long-term Medi-Cal in a skilled nursing facility, died, and had owned a home that was left to she and her brother, but the Medi-Cal issued a recovery request for $250,000. So unfortunately for them, there's really not a lot they can do because their mother didn't, or they and their mother did not protect that asset prior to or shortly after getting on Medi-Cal, at least prior to their mother dying, from being exposed to recovery. The things that expose your assets or protect your assets from being recovered from Medi-Cal is if you put them into a trust or you do a life estate, an irrevocable life estate on the property, anything that would take it out of a probate situation. So unfortunately in this situation, the house was still in the mother's name, and so Medi-Cal can recover from any assets the mother had during life. One caveat is, and I often get this question associated with this, is if you are faced with a Medi-Cal recovery claim, would she and her brother be liable for that debt? And the answer is no. The debt is only limited to any assets that the parent had. So the moral of this tale of caution is, if you come to be on Medi-Cal, you should contact an attorney who knows the Medi-Cal benefits, planning, and recovering statutes and regulations, and get a consultation to make sure you protect those assets from any recovery that occurs at your death.